This is Mike Franklin, a property tax guy. Today, we're going to review my lawsuit against the city of Syracuse. On the 3rd of August, we had a hearing on the case. It's a freedom of information law case against the city of Syracuse. I had requested some assessor data, comparable sales report, comparable assessment report, cost valuation report, et cetera, and they refused to provide them. They did provide me the comparable sales report just minutes before the bar hearing. It'd be nice to have it a little sooner so I could, so we can have a proper a bar hearing. But they couldn't be bothered to do that, and they just thumbed their nose at me as it pertains to the comparable assessment report and the various cost valuation reports I'd asked for. I think I also asked for the sales analysis report. But and they decided they were going to spend a month and a half before they'd give me a decision to deny it. Just kind of jerk me around as much as they can, because that's what they do. And so, we finally we finally got the trial on the matter. Right in front of you is the case in New York State e-file. Here's the petition, the order to show cause, which helped move the thing along a little bit. So it only takes 6 months instead of a year. Let's see, all these various exhibits. I showed where examples of where other assessors had no problem providing the data. One of them provided it within 3 hours. Another provided it within 3 days. Another within 3 weeks. They have 20 days, but the city of Syracuse doesn't even start thinking about whether or not they're going to give it to you. Well, they knew they weren't going to give it to me, but they just wanted to jerk me around and wait a month and a half to deny it. And so then we had to file a lawsuit, and we had the trial, and we'll see what the judge does. It's extensive. My attorney did a lot of work. She did a great job, and it's in the judge's hands, and it'll be up to him. You do what you can, and the cards fall where they may. My observation of the actual hearing itself, beautiful courtroom. The sound system's terrible. You can barely hear people. You would think after all these years, the courts would have that figured out. You need to hear people in a trial. The court reporter had difficulty hearing everybody. She had difficulty hearing me because, of course, I talked too fast. So I had to keep trying to. So they kept trying to slow me down a little bit because I get a little fired up about these things. But anyway, hopefully she got the whole thing. I ordered the transcript, so I should have that soon. But it was interesting. I took the stand, and I was questioned by my attorney and by the attorneys for the city of Syracuse. When my attorney questioned me, I was able to say a few things that were on my mind, and hopefully the judge heard it. You never know what the judge hears and what they don't hear. The city of Syracuse assessment commissioner was questioned, and my attorney questioned her, and he bold-faced lied under oath on the stand, perjured himself, and he just gets away with it. It's just amazing to me. I think he perjured himself at least once. I'm going to read the transcript to see where the other one was, but he said he didn't know what a comparable assessment report. If you're the commissioner of assessment and you don't know what a comparable assessment report, you shouldn't be the commissioner of assessment. And also, the residential properties in New York are valued based on comparable sales adjusted for unequal. If you haven't run a comparable assessment report, it means you haven't adjusted for unequal, which means you're in violation of RPTL 305, the uniform percentage of value. Properties must be assessed at a uniform percentage of value, and if they didn't run that report, they likely didn't adjust for unequal. So that's how it's pretty easy to beat these guys. What else is there to say? Their attorneys questioned me after they got some responses. They pretty much shut right up because they didn't want any more of that. Because I got to educate the court about what the heck's going on, and they decided maybe we shouldn't ask this guy any questions. And so I think that went pretty well. I may have been a little too rambunctious. I don't know. I've had 500 SCAR hearings. and I know how to behave there, and what happens on what the response is. But this is a trial I've never had experience with, first time, and I guess you'll live and learn, and you know, some of the issues weren't addressed in the hearing. I don't know if they needed to be addressed because they're all part of the record right here. So the judge should already have this stuff, should already have reviewed it. But the thing is, it's probably hundreds of pages of stuff. He shouldn't have to read all this stuff. This whole case boils down to 3 issues, and it could be done in 1 to 2 pages. Number one, if they have the ability to extract data from the computer storage system with reasonable effort, they're required to do so per Public Officers Law 89.3A. And I think we established that they have the ability to do so, seeing as every other assessor in the state does. And I have countless examples of assessors who have. And actually, my lawyer was able to get Matt Oja to acknowledge that he could. And then she said, "I have no further questions." It was hilarious. It was kind of like when Tom Cruise was questioning Jack Nicholson and got him to admit he ordered the code red. Well, it was kind of like that, but not so dramatic. It was very kind of low key. And I hope the judge heard it. I think he did. I hope he did, because that's pretty much the whole case right there. And then so number one is, they're required to do that. And also number two, and doing so is not the creation of a record. So there's no exemptions for providing this data, because it's reports from the final work product of the assessor from the tentative roll. And the third is, if they have no statutory basis for denial, attorney's fees are mandatory. They're not at the discretion of the judge. The judge can determine what's reasonable, but it's mandatory. The attorney's fees are mandatory. So I think that he can maybe adjust what the hourly rate is, but he can't deny. But I guess judges can do whatever they want, so we'll find out. But I think the demeanor of the judge was good. Sometimes these judges will talk down to him, and but that didn't happen. I thought it was very level-handed, and he was inquisitive of both sides, and he was attempting to I think be fair and reasonable as far as I can tell, and and based on everything that I've seen from this case and the last case, that he will act in good faith. I was pleased with what he did the last time. And he when my attorney issued the order to show cause, I mean, he got on it right away, which was fantastic, and I really appreciated that. So we can get this data in time for my client's hearing, so they can have a proper assessment hearing, appeal that they're entitled to by the Constitution, literally. So what more is there to say? I think my attorney was great. I think I did pretty good for the first time. I may have been I may have gotten into some things that were irrelevant. I may have gotten a little too wound up, but I think overall I did okay. But other people might feel differently. As far as the city's attorneys, I think they were put in a bad spot. I think that they don't really have experience in this stuff. I think the one guy was into medical malpractice. I don't think this is his area of expertise. I forget what the other guy. The other guy's a real young guy, and the young guy seemed very, very nervous. And but I'll be frank with you. I think they were out of their league. But you never know what the judge will do. It's you don't know what the judge heard, and we'll see what it is that he has to say. I'll be anxious to see it. But to me, if there's any justice, they'll be giving me everything I asked for, and they'll be paying my attorney's fees and costs. I believe that's what the law is, but we'll see what the judge says. It'll be very interesting to see what it is that that he writes up. It's it's been a very, very interesting process. It was very easy to get in and out of the court, and deal with the courtroom. The security people were good. Just no issues with that. And like I said, it's a beautiful, beautiful courtroom. Just the sound system's lousy. So I have no complaints. The filing fees are $430. Well, you're tying up this big fancy room and a judge's time. The guy's a CPA and a lawyer. His time's valuable, and the court and everything. So, I think I'm getting my money's worth. But we'll see what the decision is. My opinion may change, but it's in his hands, and I have faith. I think I got the best judge for this job. Because of his CPA background. I think he comprehends all of this stuff, and I think that the city of Syracuse's defense, their only defense, was to try to confuse the judge, and they did everything they could to do that. And so the question is, were they able to confuse the judge? But I think it's a pretty clear-cut case. But we'll see what it is that he has to say. I think the city of Syracuse, their behavior is outrageous. They're wasting the taxpayers' money needlessly over this nonsense. They could have. I have a video that demonstrates that it takes 2 minutes for them to run that report. So all told, it might take 15 minutes, 15, 20 minutes to run all the data that I requested. But instead, they want to have 2 lawsuits over it and spend all my time, the court's time, 2 attorneys, the commissioner of assessment. They don't care. It's not their money. Oja is getting paid one way or another. Their attorneys are getting paid one way or another. So I'm going to attend their judicial department, their legal department budget hearing next year, and educate the committee that's doling out them money, and explain to them that they probably don't need to provide as much money as they do because they're taking on frivolous cases. They could have given me this data in 15 minutes, and that would have been the end of it. But they can't do that. It's ego, some sort of fiefdom issue, but they're violating the law, and something. And I hope the judge recognizes that and does something about it. The 89-4 CII calls for mandatory attorney's fees. The intent of the legislature was to award attorney's fees to motivate the municipalities to comply with the law. So I'm hoping I can't get anything for my time that they've wasted of mine, which is ridiculous. But we can get our attorney's fees and our costs back, and if we can get that, that should send a message to them that they keep doing this. I'll sue them every damn year, and it's going to cost them more and more money, and people might start losing their jobs. Maybe that'll get their attention. This is Mike Franklin, the property tax guy.